This week, the president rejoicingly announced the passage of another milestone in his American Rescue Plan, announcing that half of American adults had been vaccinated against COVID-19, followed by a similar announcement by the nation's only physician serving as state governor, Virginia's Governor Ralph Northam, whose state health director, Mohammed Norman Oliver, a graduate of a baccalaureate degree conferring institution that required no college entrance exam, and who had not only in February 2020 issued a declaration of communicable disease 1 month too early, while ignoring reiterated advice from the World Health Organization a week before to begin enhancing the state's capabilities to perform tracer contact follow-ups, who appeared to the press not even to understand the role of tracer contact in preventing the spread of an emerging disease as late as May 2020, and who by June, after announcing in April 2020 an intent to hire not in months, but within weeks, up to 1,300 new personnel to perform the critical task of tracer contacts follow-up, had collected over 6,000 resumes, but had hired only a total of 168, 3 months after the first laboratory-confirmed case had been identified in the state. Under the law of Virginia, actual malice can be defined as gross negligence. When Governor Northam and State Health Commissioner Oliver were beginning to lock down the entire state, causing unemployment claims to jump from just above 4,000 to over 46,000 in just 1 week, projected to double by the beginning of summer. Against the warnings of the World Health Organization, less than a month before, who had not only stated in plain English that COVID-19 was not a communicable disease being transmitted from person to person, based upon a robust examination of over 55,000 laboratory-confirmed cases and their tracer contacts in China, the proper protocol, but also had reiterated 3 times in that report the need to protect the elderly in nursing homes, who by May 2020 represented over half of the fatalities in the Commonwealth of Virginia, while the governor had feloniously evaded the sheriff for the city of Alexandria to avoid litigation that had been brought in part to prevent that harm. According to surveys conducted by the Pew Research Center, approximately 73% of Americans were still yet confident that they understood the science of a novel coronavirus, while scientists at that same time were by April reporting to the New York Times that they were even baffled by just the very first case of infection in the United States that had arrived in Seattle through a 35-year-old traveler returning from Wuhan, who had failed to infect as many as 68 close tracer contacts, despite a 20-hour trans-Pacific flight, a 25-mile share ride, and casual social interactions with others for as long as 4 days around Puget Sound, but whose specific strain of virus, as determined by genome sequencing, was found in as many as 39 others throughout the entire state, with whom he had not even any indirect contact. A transmission spread not consistent with a communicable disease, but rather with a pathogen that is being deployed as a weapon of terror. By July 2020, according to Pew Research Center, 76% of Democrats said that they were confident they understood the science of a novel coronavirus, while confidence amongst Republicans had declined to 66%. Evolving science that even found the nation's only physician serving as a state governor, Ralph Northam, perplexed. During his Labor Day COVID-19 update at the beginning of September, when he finally conceded that the disease was not being primarily transmitted by droplets, but by aerosols. It continued to promulgate preventative measures that would be more correctly suited for droplet transmission, such as social distancing and masking mandates. The modification to aerosols as the primary transmission means was a basic transmission model about which epidemiologists have been familiar for almost a century, and 239 scientists, including Virginia Tech's rock star environmentalist Lindsay C. Marr, had endorsed that theory of modification in July. A theory that would present the possibility that not only small particles might be able to infect persons with an infectious dose, but might linger as long as 2 hours after the infected person has left. And they submitted that report unprecedentedly to the World Health Organization and World Health Public Authorities. So, beyond the science, how many Americans who would never argue a case without an attorney in a court are confident they understand the release from liability that the vaccine manufacturers actually receive? Test question: can Pfizer, Moderna, and Johnson & Johnson be sued for the vaccines? And if so, under what circumstances? It is often said, if you are ever invited to a poker game and don't know who the sucker is, you may feel a slight pinch. According to federal authorities, the Public Readiness and Emergency Preparedness Act, or PrEP Act, provides immunity to qualified individuals. And PrEP Act declaration amendments preempt requirements that would result in a qualified person being unable to prescribe, dispense, or administer vaccines as authorized by the state or U.S. territory. While the PrEP Act also provides for a countermeasure injury compensation program for certain individuals who sustain injuries or die from receiving the countermeasures. Under the PrEP Act, licensing laws that are less restrictive than those in the Declaration amendments are not preempted, and states and U.S. territories determine authorized vaccinators in their jurisdiction, as has been occurring in the Commonwealth of Virginia. While popularly understood as granting an unlimited release from liability to vaccine manufacturers, under the PrEP Act, immunity applies only to licensed health professionals authorized to administer covered medical countermeasures under the law of the state where the countermeasure is administered, and other individuals identified in the declaration by the Secretary of Health and Human Services, HHS, to prescribe, dispense, or administer covered countermeasures, including the COVID-19 vaccine. Moreover, under the terms of the PrEP Act, when the Secretary determines that a threat or condition constitutes a present or credible risk of a future public health emergency, the Secretary may issue a PrEP Act declaration. And the declaration provides immunity from liability except for willful misconduct for claims of loss caused by, arising out of, relating to, or resulting from the administration or use of covered countermeasures to diseases, threats, and conditions identified in the declaration. In the Commonwealth, the Virginia Supreme Court in 1979 decided a case, Featherall v. Firestone Tire and Rubber Company, that had relied upon Section 388 of the Restatement Second of Torts, and in this case arising under the jurisprudence of products liability, stated the rule that the manufacturer of a chattel will be subject to liability when he A, knows or has reason to know that the chattel is or is likely to be dangerous for the use for which it is supplied, and B, has no reason to believe that those who use the chattel is supplied will realize its dangerous condition, and C, fails to exercise reasonable care to inform them of its dangerous condition or of the facts which make it likely to be dangerous. In the Commonwealth, distinct from a latent defect or a defect which reasonably careful inspection will not reveal, that is, integral to the damaged property by reason of its design or manufacture or construction, or a defect that cannot be discovered until later, rightly understood, a patent defect on a showing of a preponderance of evidence in a statement of a legal cause of action upon which relief can be granted by a court deciding the case on the merits. Any attorney can inform you that a patent defect is only that defect that is by the manufacturer known or discernible by reasonable inspection, a defect so obvious that only a blind or ignorant person might miss it. And under a products liability theory arising from a patent defect, a manufacturer may be held liable only for work that they completed for patent defects of which they were aware, or for breach of any express warranty made by the manufacturer. And applying this rule in a normal arm's length transaction performed in good faith reliance, the controlling rule is very clear that when faced with a patent defect, the offerer is obligated to bring the situation to the offeree's attention if he intends subsequently to resolve the issue in his favor. This is a duty to warn. Furthermore, as observed in Jones v. Meatpackers Equipment Company, a Fourth Circuit case decided in 1983, in the Commonwealth, the year in which Ralph Northam graduated from BMI, the warnings that are owed to a potential consumer or customer may include the reliability of the third person as a conduit of the information and the magnitude of the risk compared with the burden imposed on the supplier by requiring that he directly warns all users. So for review, accordingly, COVID-19 vaccine manufacturers like Moderna, Pfizer, and Johnson & Johnson under the PrEP Act would not be immune at all where there is a showing of willful misconduct in claims of loss and claims not involving a direct loss from the product, while other third parties would not find immunity from conduct arising from the administration of the vaccinations and their distribution, where there is also willful misconduct. And this list of third parties might include those research providers like Scripps Research Center, the authors of the definitive zoonotic evolution study upon which many relied to stress the urgency of providing the vaccines, that arbitrarily and capriciously had determined that a validated less than 5% infectious pathogen, even if a product of zoonosis, might possess the ability to proliferate into a pandemic pathogen of its own accord as a communicable disease, while flatly rejecting the more probable theory that the pathogen did not arise through through natural means, but also those administrators who, in furtherance of the fraudulent misrepresentations, promoted that product. Other third parties might also include the Data Institute, which had proposed the adoption of the UNESCO precautionary principle, a theory rejected by American courts but used by Governor Ralph Northam to mandate masks across the state. The precautionary principle is rejected in American courts because it has been determined to be only speculation of damages. And speculative damages are traditionally eschewed by American courts.
I believe it's one of the most ghostly manifestations that I have ever seen. Whether it is real or simply conjecture, one of those things that people seeking to find some mystery to fool themselves into believing, but with some other perfectly rational cause is a question that only you can answer with your capacity for reason. Impossible? So was Xeroxing and holography just a few years ago. In fact, so were videotape replays like the one you're watching right now. People have been claiming an existence of God for thousands of years, and maybe one day we will finally know the answers as to how and why and what. What a tremendous gain that would be for science, but what a tragic loss for storytelling. No one knows the day nor the hour when all mysteries shall be revealed, but we'll be watching and we'll be waiting in earnest, incessant, and fervent prayer for the advancement of the kingdom of God. Be sure to join us next time as events evolve with science and faith in a pandemic election that some have claimed is the presidential election of their lifetime.
This is a no-brainer, folks. It doesn't get any easier than this. My name is Major Mike Webb. By God, I am running for Arlington Public School Board. If it is to be, it is up to somebody to tell you to do what to do. Let me know how that works out. This advertisement was authorized by Mike Webb. End of the day, I really don't give a damn. It's not my department, honest. And y'all come back now. Here. Honest.